Okay, we're on section 9 in remedies, and we have a couple of different things to talk about with respect to contracts for personal services and enforcement. We also have, and I want you to look at them for Thursday's class, rules 26, 27, and the discovery rules. Because if you're doing civil litigation, much of your time is spent in discovery, and we don't spend enough time on it in law school, but you ultimately will spend an ungodly amount of time in the real world with respect to discovery matters and disputes, and that's where cases are won in law. So look at those rules, and actually look at all 26 through 37 for Thursday, and we'll talk a little more in depth about that as well. But I can't stress enough how much time we spend in the real world on discovery matters, and it's where we make a lot of money, and we hopefully are able to succeed with our cases. But it's important to understand those rules and be able to do it right, because there's a lot of legal fees and time spent fighting about various things in discovery. So the contracts for personal services, we start out with ABC versus Warner Wolf, which is an older case, and we'll move forward from there. But I'm sure you did some work with contracts for personal services when you did contracts initially. Did you? Did you do any personal service contracts stuff when you did contract law?
That was more so in like UCC Article 2, where it ties in with the hybrid contracts and whether you're offering services and the goods.
So you did it in UCC?
Well, there's also the Lady
That I
Duff
remember.
Gordon.
The what?
Lady Duff Gordon case.
I don't know that one. What's that one?
That one was where
That paint the picture?
the exclusive
No.
contract, where they had to have an exclusive contract for her, but he didn't represent her to the fullest possibility.
So what was Lady Duff Gordon about?
Well, she was an actress, and like he was basically trying to get her work
Get
for
it.
her acting career, and he didn't perform to the ability that she felt that.
So
he
what was the
should.
case? What was the issue in the case?
She didn't get as many job offers as she was supposed
Okay,
to.
but so what? So she sued him for poor performance of the
Right.
contract of the
Correct.
of his
Of
personal
his-
services
of his-
contract.
Right.
Oh.
His section of the contract.
Okay, when I was in law school, we used to read a case about they wanted someone to paint their picture. And the question is, can you get specific performance of a personal services contract? Did you do anything like that? No? Okay, well, we're gonna do it today.
Okay.
So let's talk about this, because this is to me it's an interesting case, and the whole section is problematic and interesting to me as well. But it's ABC versus Warner Wolf, who was a sportscaster, and this is an industry where they have fairly extensive contracts that require, usually almost always coupled with a non-compete arrangement, where you can't just move from one station to another, because they don't want to build your brand up and then have you go to the station in the same city right away, because that means a lot of viewers might well follow you. So it's a pretty standard practice that there is oftentimes some significant period of limitation when you can work in the same market and work for competitors and the like. And this was a 3-month period where Wolf was prohibited from going to another station in New York during that period. And so he had an agreement with ABC, as you saw, and at September 79, he met to discuss with them the terms of the renewal of the contract. His contract had been negotiated with ABC, and so that it had a couple of different periods here within it that were important. He entered into this employment agreement that was to terminate on March 5th, 1980. The contract contained a clause known as a good faith negotiation and first refusal. It says, you agree, if we so elect, during the last 90 days prior to the expiration of the extended term of this agreement, to enter into good faith negotiations with us for the extension of this agreement on mutually agreeable terms. You further agree that for the first 45 days of this renegotiation, you will not negotiate with any other person or company other than ABC TV or ABC. So that would bring them, so you're talking January, February, or actually December, January, February. For all intents and purposes, he's supposed to be working with them, and during the first 45 days, only them. And then in the event that we don't get able to reach an agreement, you agree that you won't accept work in any other market, in this market, in any market actually. It says for a period of 3 months as an on-air sportscaster, sports news reporter, commentator, blah, 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 without first giving us in writing an opportunity to employ a right of first refusal, in essence. You see the language. On February 1st, 1980, Wolf first met with ABC executives in September '79 to discuss terms of the renewal contract. They made proposals back and forth, and they were unable to finalize the matter. They agreed to try, but they weren't. But during this same period, which is September '79 and thereabouts, till October, Wolf met with representatives of CBS in early October, right? Now, nothing in the agreement prevented him from meeting with representatives of CBS in early October, because the 90-day period on exclusivity and negotiation didn't start for another month. So what happens here is that on February 1st, 1980, when we're in the last 45-day period of the agreement, Wolf and CBS at that point orally agreed on the terms of the arrangement. And what they did is they gave him two forms. They divided the agreement in two ways. A, you would be a producer, in essence, off-air person for those 3 months when you can't be on air under your ABC agreement. Then it'll convert to you'll be an on-air personality, because that's really what they're hiring them for. So what Wolf does is he signs the production agreement on February 4th, before he's even finished negotiation period with ABC. And at the same time, CBS agreed in writing in consideration of the 100, so they had an option to hold open the offer of employment to Wolf as a sportscaster. The reason he doesn't sign that offer at that point is if he does, he's got to give ABC the right of first refusal. That's the deal. So if he signs that and accepts the offer of employment, ABC can match it, and he doesn't get to go anywhere. And instead, what they do, obviously with consultation of the lawyers, they say, well, we won't make an offer. You won't have to give them the option to match, and you'll be the producer for 90 days. You will have an option when that 90-day period expires to accept the terms of this agreement. We're leaving open for you to accept until then. And that's what they do. And what happens then is ABC ends up out in the cold. And so then ABC files this suit in May 6th of 1980, when they had realized that he's now working with CBS, that he is going to be his on-air personality with CBS, and that in essence they feel that he was cheated out of the terms of their ABC felt that they were cheated out of the terms of the agreement because they manipulated the period and weren't dealing in good faith. So here is my first question for you. Hopefully you really did look at these facts, because they get a little complicated. But at the end of the day, if you're one of Wolf's lawyers, you again looked at this contract and you said, well, once we get to this 90-day period, we got problems, but we can talk to them before then, and there are ways then we can structure an agreement with the competitor at better pay by just using the language of the agreement and making sure we don't violate it. So I guess my question to you is were Wolf's lawyers ethically challenged? Was this below the belt type of lawyering, or is this precisely what we get paid to do? Is that we have an agreement, there is nothing in that agreement that prohibits him from negotiating with CBS prior to the 90-day kick-in period of the last 90 days of the contract. There's nothing in the agreement that says he can't strike a deal for production or other work with CBS during the last 45 days. And why shouldn't he, just like ABC, use the terms of the contract to his advantage? Or is this a little sketchy?
I think it's a little sketchy, to be honest with you. I don't think that it was something that he should have just done, started negotiating these contracts when he's already tied to a different organization.
Well,
Competitor.
because do you think that he can't negotiate in good faith with ABC if he's already, in essence,
Right.
betrothed to someone else?
Right. He's playing for both sides of the team.
Well, he's playing for his team,
Yeah, he's playing for his team.
but ABC, CBS must play for their team, right? So what's the harm? Everyone's got a good lawyer at this table. Why, if ABC wanted an exclusivity period that was the entirety of the contract, why didn't they write it that way? Go ahead.
I think there was nothing ethically wrong by just reading through the case that the lawyers did. And I think it's kind of unconscionable to tell this guy that he can't go over there and negotiate when this company probably on the back end was probably negotiating somewhere else. In reality, now obviously the facts don't show that, but just from a negotiation standpoint, I don't see nothing wrong with this guy using the language. That's what we do as lawyers.
That's right.
Take the words and kind of construe them in our favor. So I don't necessarily see nothing unethical about that.
Well, here's my, and I don't necessarily, I'm asking the question because people will ask us, okay, well, tell me what I can and can't do under the terms. Actually, they don't even say that. They tell me, is there a way I can negotiate with CBS because they've got a much better deal there? Well, how would I structure it? Or am I tied to ABC? And the fact is, I don't think anyone, or certainly ABC's lawyers, maybe even his own lawyers, didn't think at the time they were drafting this language that what that meant is, okay, well, September and October you can negotiate because there's no 90-day exclusivity period, and then we can structure it on the back end slightly differently so that you don't give them the right to match. I mean, that is part of what ABC's now worried about is, well, where's our right to match? Well, the right to match only arose under certain circumstances. We didn't structure the deal that way. We structured it in part, one would argue, or he won't argue, but ABC would argue, to specifically cheat us out of that good faith negotiation period. You can't in good faith negotiate with us when you're tied to CBS, a competitor of ours. But the fact is that why should we worry about ABC? They have lawyers. If their lawyers didn't protect them as well as they would like, that's on them. That's not on Warner Wolf's lawyers, is it? I mean, that's the way he would see. Now, ABC files an action seeking specific enforcement of its right of first refusal. They say, listen, we know everyone knows what's going to happen here. He is going to accept CBS's offer once that 90-day period is over, and we are prepared now to match that offer completely. And that's what we want specific performance of. We want to, under the terms of the contract, have that right of first refusal, bring him back here, make him work for ABC under that provision that he and we negotiated freely and decided that that's what would be appropriate. And by the way, ABC paid for that, right? They paid him likely handsomely for much of this period. And so that's the question we've got before the court is, can you get specific performance of a personal services contract? He is supposed to be a sportscaster for ABC. His choice now was to work for CBS in that capacity, and ABC is saying, wait a minute, we have a right of first refusal. We want specific performance of the terms of this agreement, and specific performance under the circumstances would mean we have the right to match. He comes back to ABC, all is forgiven, and we move forward. Can you get, and this is the question for equity, can you get specific performance of a personal services contract? Can you make him come back to ABC and work for them in accordance with the terms of the contract? Look at Roman numeral 3A, because this is an important point, and I'm going to say starting off point, but it's only a starting off point because of some of the other cases in the back end of this. But from a standpoint of typical workers and the like and their companies, it says Roman numeral 3A, courts of equity historically have refused to order an individual to perform a contract for personal services. Originally, this rule evolved because of the inherent difficulties courts would encounter in supervising the performance of uniquely personal efforts. And that's what you have to start to think about here, right? It's one thing to say, convey the real estate at 1 Main Street to the other side under the terms of the agreement of sale. It's another thing to order an individual to perform personal services contract because, as it says here, not the least of which is, well, how do we know you're going to do a good job with it? You know, this was the case we read at the time, back a long time ago in law school, is the person was supposed to paint your picture. And they said, well, we can order them to paint your picture, but you may not like what it looks like by the time it's done. And so then how do we know that you're performed as well as you possibly could have? And so the problem became one of, well, how are we going to gauge performance with it? How do we make sure that it was done in accordance with what you would want when it's for personal services? When you're a salesperson at a company, or you're painting a picture, or in this case, you're a sportscaster. So now he gives less than a full effort and you're dissatisfied with that specific performance. How do we know that he wouldn't have been going forward not the same sportscaster he was in the first year? It's going to be very difficult to police an order for personal services contracts, and that's what they're worried about, because it deals with uniquely personal efforts, right? Uniquely personal efforts. It says, though, there's been exceptions to this. As you look in Roman numeral 3A, it says, when an employee refuses to render services to an employer in violation of an existing contract, and the services are unique or extraordinary, an injunction may issue to prevent the employee from furnishing those services to another person for the duration of the contract, such negative enforcement, right? Okay, we're not going to make you come back to ABC, but we're not going to allow you to work for CBS either. That doesn't have the same performance problems, because we know you're not going to work. We can't make you come back for ABC, but because you violated that, we might be able to negatively enforce the provision and refuse to allow you to work for someone else. But the problem also comes in is that shouldn't the person have some ability to work as well, because there is some level of anti-competitive practices at work here. And it has to be rigorously examined and only specifically enforced under certain circumstances. And so if you look at the top of page 1099, it talks about if they involve trade secrets, customer lists, goodwill of the employees, or there's unique nature to these goods, the services that maybe under those circumstances it makes sense to think about prohibiting that person from working for someone else. It's very difficult to get, and almost impossible to get them to order specific performance of a personal services contract, but if you don't want to work for them, maybe you're not going to work for anyone else in the meanwhile either. But there's also this other part about you're taking away someone's ability to earn, to their livelihood and the like. And so that becomes a problem with respect to the whole notion of indentured servitude in personal services contracts if you were to issue specific performance. There is no non-compete beyond that 90-day period, and there is no non-compete in these circumstances for the job that he's agreed to do. He's a producer. That's not an on-air personality. That's a backroom personality. Not even a personality, it's a backroom person. So the reason he's so valuable is because his on-air persona is what they're paying for. The problem is there's really almost no way that you can specifically require him to come back to ABC and work there, because you'd make him an indentured servant, and you'd also then have very, very grave difficulties trying to police whether he's adequately performing those services that you're paying for. And so here, as they would have historically, they say, we really can't order specific performance. That's not to say that ABC can't sue for money damages. As it says here in the second to last paragraph, ABC has been damaged in some fashion, and Wolf shouldn't escape responsibility for the breach of his good faith negotiation obligation. He did steal that from them, but we're going to have to compensate them monetarily and not equitably under the circumstances. They have the ability to sue for money damages here, but they do not have the right to get specific performance of a personal service contract. It's almost impossible to do. Look at note 7. It says, even if Wolf had breached the first refusal provision, which I think in part, well, I think he definitely breached the good faith negotiation provision. First refusal, what he did was clever lawyering. Provision said one thing, and it happens all the time. We wrote it a different way. He's going to honor the 90-day not on air provision, and he doesn't have a first refusal. The lawyers wrote it in such a way that that doesn't kick in. And listen, we can say, we can raise the issue where Warner Wolf's lawyers ethically challenged, but ABC certainly had competent counsel. They must have well-paid counsel representing their interest. They should have given this thought as to the ways around that. And that's why, you guys have to think about sort of the belt and suspenders approach when you're drafting contracts. If you leave a loophole, we've seen this a bunch of different times. We saw it in Pier 4, we see it again now, then someone on the other side is going to be looking at it saying, well, where are the escape routes here? And that's just part of our job. Now, we can say down the road, well, that's because he's sleazy or this or that. But if we leave holes that people can drive trucks through, then you should look in the mirror too, because certainly your client is going to be looking at you as to why that hole was there. And this shouldn't have happened. Shouldn't have happened with competent counsel all around. And I do think it's a clever manipulation of it. But it is what it is. You left the hole. All I'm doing is taking advantage of it to my benefit. And that's what people do all the time. We have to make sure that we're looking at things from a 360 degrees. And that's why we tend to overwrite things and use the belt and suspenders approach, saying, I know it may say it, but I want to make entirely clear, during that 90 days, whatever offer he has received or will receive that was negotiated during those 90 days, we have the right to match. I mean, maybe there's a way to fix it without it being so ambiguous to make it meaningless. But here, they didn't do it. And ABC, if they wanted more, they should have paid in written for more than they had. But so outside the personal service area, by the way, outside the personal service area, then oftentimes they would have had to give the right of first refusal. But personal services are impossible to actually think of in that way, that's what the way you would approach it. So what they're gonna do here is what they've done historically, is refuse specific performance on a personal services contract. They're likely going to sue and will collect damages, and that'll be interesting as to how they value those damages as well. But that's, they're not gonna get specific performance of it. The next case we have is a First Circuit case, Vanessa Redgrave versus BSO, Boston Symphony Orchestra. Yep.
I just wanted to share a very similar situation that happened to me, right? It's on a minuscule level compared to this one. But I had I was in this one, I'm still in this company actually, and I started in one position. They gave me a non-compete, right? And then they wanted me to go over to another position, and they gave me another non-compete. The first non-compete addressed customer lists and everything like that, and the second didn't address the doctor database. So what I did was, I work for a company with the recruit expert physicians, and they're pretty much that's their how they make their money, right? So what I essentially did was, I accepted the job, didn't sign the non-compete, the new one, and I took some names from the doctor database and went to competitors to see if the competitors would pay me more. So I'm really just mentioning it because, just to go back to our colleagues, just to let you know, that's not underhanded. That's just bad lawyering on the lawyer's part, drafting that contract.
Well, not just drafting it, but then making sure whether
Right.
the contract is signed or not.
Right, right. So I just wanted to put that out there. I don't think that's sleazy in my part at all. I just think that I found that at that point I was a business entity, so I just had learned everything. So I just saw it as a window for me to see an opportunity to make more money. So I just wanted to
Even
share
without all the non-compete, you could have been sued for those.
that. I could have, but I physically wrote the names down. I didn't print anything off, and I took it over there. Then I looked up some mass law as to non-competes.
Well, in mass law, there actually is a very new statute on mass non-competes, and the provisions have changed significantly with respect to their enforcement as well, because of the technology companies here. Let's do.
Sorry, I just
No. It's interesting. I don't know how much you want to discuss.
I mean, I really don't care because it's like I'm still with the company. I signed a new agreement.
Oh.
Anyway. This was just a situation. I used it as a way to see if I can go to their competitor and see if I can get paid more money and say, hey guys, I know a whole bunch of heavy hitter doctors, and see if they was willing to give me money. But they weren't willing to do it and meet me on my terms. So I said, oh, well, whatever, sign the agreement. So sorry, I just wanted to.
No, not at all.
Just
It's
share that.
well, by the way, I mean, many companies have the non-competes now, and the agreement not to disclose, the confidentiality provisions, and the problem, I think, is with some of these things now, mass law protects to a much greater extent than it has previously. But the problem is we do business on a global scale now. So what it is, how far, what is the region you're restricted from working in? What is the area you're restricted from working in? The case we just finished in Connecticut had all these various non-competes and the like, and we ended up litigating it significantly with respect to what both the company's breaches and the employee breaches for these reasons. And it's, big business, big money. Let's talk about Vanessa Redgrave versus BSO, because it's an odd twist on the personal services contract. So Vanessa Redgrave was supposed to perform at the BSO. And she was very outspoken, and she was talking about her various political views, that that the Boston Symphony Orchestra at some point was concerned that her support of the Palestine Liberation Organization would hurt her, would hurt the BSO because of the supporters from Israel and her outspoken views generally. Many of the BSO subscribers didn't want her to appear at all, and urged the BSO to cancel her performance. which the BSO ultimately did. They said, you know what, we don't need this baggage. We don't need all the turmoil surrounding it, and we certainly don't want to annoy or aggravate our big donors. And so we're going to cancel your performance. And what they did is they agreed to pay her full performance fee, even though she was not going to perform. And so that wasn't enough for her. So what she then did was file suit in Massachusetts, federal court, and she wanted the court to order that the BSO be specifically required to perform the contract they agreed to, which means allow her to perform at the Boston Symphony Orchestra as previously agreed. So she's suing for specific performance, which is an interesting twist on it, on the same problem that we've seen historically. So what she files is a multi-count complaint in federal court, which is sort of a textbook case on properly pleading your various causes of action. So she files this federal court complaint, and it contains 10 claims, 6 against the BSO and 4 against the defendants whose identity is not yet known and who are alleged to have put pressure on the BSO to cancel the concerts. So we can file a suit. We have it against a known entity and then against other individuals who are yet unknown. Through the course of discovery then, obtain who these other people are, amend the complaint to put them into the complaint, and proceed against both the BSO and whoever these people end up being, who I'm able to obtain that information through discovery. That's a permissible way to proceed. It's again a little unusual, but that's fine. She's got claims against the BSO, one of which is a breach of contract claim requesting monetary damages. That's just a sort of straight breach of contract claim. Breach of contract claim requesting specific performance. Tortious repudiation of a contract, again for money damages. Tortious repudiation requesting specific performance. And then we've got a couple of federal statutes, 42 U.S.C. 1986 and her Massachusetts Civil Rights Act. So we've got some common law claims, some state statutory claims, and a federal statutory claims. Because the federal claim has a valid basis to be, because all of the claims are connected to the federal claim that has a valid basis to be in court, then the others all get what we call supplemental jurisdiction, so they all can be heard at the same time because they all arise from the same set of facts. This is the way you plead, whether you're in state court or federal court. We've talked about this when we did CIPRO. All of your various theories at one time. There are not that many here, really. She's got a couple contract, couple tort claims, one statutory civil rights violation, and one federal civil rights violation claim. Not uncommon at all. Whatever claim she doesn't plead, she's going to lose. So this is why you do it this way. And because they all arise from the same nucleus of operative facts, they all can be brought at one time. And so she files, they're served, then off to the races we go. They file motions to dismiss. So first of all, on the breach of contract claim, she says they entered into a contract. She's to be paid $31,000 in exchange for her services. She's ready to perform, wants to perform. BSO says, you're not going to perform. It's not worth it to us to annoy our benefactors. We'll give you $31,000, but there's going to be no concert. Contractually, that's all that the defendant is obligated to do. They couldn't get specific performance to get her to perform if she chose not to. Their remedy would be damages. She can't either get the BSO to be ordered to allow her to perform. What she can get is what she's lost, which is that $31,000 that was contracted for by way of the fee. Even though I think she could argue that not performing at the BSO means that she's lost potentially other revenue-producing opportunities, stature. I mean, to think, you know, we'd all be telling our mums and dads that we were performing at the BSO, so there's something to be said for that, not that she wasn't famous already. But the fact is, she's still not going to get specific performance on a personal services contract. And BSO argues she can't even get incidental or consequential damages here. The best she gets is her 31 grand and nothing more than that. Top of page 234, the fundamental principle of law for breach of contract damages is that the injured party shall be placed in the same position he would have been if the contract had been performed, so far as loss can be ascertained to have followed as a natural consequence and to have been within the contemplation of the parties as reasonable men as a probable result of the breach. And so insofar as compensation, therefore, in money can be computed by rational methods upon a firm basis of facts. That means she's likely going to be limited to her 31 grand, and she is not going to be allowed any other damages in all likelihood. She's not going to get specific performance because, as it says here under Roman numeral 3, the arguing is that it's barred by the U.S. Constitution and common law. Partly what we're saying is you're going to order this specific performance, which makes the BSO bound to do what you want. And again, on personal services contracts, that's just not likely ever to be done. Let's see. Roman numeral 4, tortious repudiation of the contract claim. She's trying to argue an intentional infliction of emotional distress claim, but on the top of 236, it tells you what you have to be able to prove in order to get intentional infliction of emotional distress. That the person intended to inflict emotional distress or knew it would cause emotional distress. That the conduct was extreme and outrageous, was beyond all possible bounds of decency and utterly intolerable in a civilized community. I don't see how she's ever going to satisfy that. That the actions of the defendant were the cause of the plaintiff's distress. That's likely. The problem is, though, when you're as outspoken as she was, you got to hopefully have a relatively tough skin, because if you believe in free speech, then you should believe in others having free speech as well to combat your views. So I think 3 is going to be hard to show that she's actually in distress. 2 is, I think, almost impossible to show under the circumstances here. And then 4, as 2 is difficult, 4 is equally, that the emotional distress sustained by the plaintiff was severe and of a nature that no reasonable man could be expected to endure. I don't see how she's ever going to satisfy that. That's all based on Massachusetts law with respect to intentional infliction of emotional distress. This business dispute hardly gets us to that kind of level. And then it says at the close of that section, it says the BSO's alleged conduct is neither the kind of systematic harassment nor the single but dramatically cruel incident that the courts have found to be sufficiently outrageous to sustain a claim of infliction of emotional distress. These facts simply don't get her to where she needs to be. What she is entitled to get are damages, but she's certainly not entitled to collect anything more than that or get specific, or no, she's not entitled to get specific performance of those contracts. She then has a couple of other statutory claims that the court looks at, both her 1986 under the U.S. Code claim as well as the Massachusetts Civil Rights Act claims. But there's no argument really here that the BSO engaged in threats, coercion, intimidation, you know, the fact is that within their contractual provision, they decided it was in their business interest to not have her perform. The damages that flow from that are what she would have earned otherwise. They're prepared to pay that, and that the likelihood is she doesn't have much more than that. She does, if she can cobble together her argument, she can move forward on her claims under the Mass Civil Rights Act because she was exercising her free speech. But the fact is that there's no, whereas the threats, intimidation, or coercion that the court is looking for in order to be successful under the act, the fact is, historically and in this case, we do not order specific performance of personal services contracts. That's the law. I gave you this Florida Panthers case because it's one of the few cases where I could find that they ordered specific performance of a personal services contract, but to me, that's what they call it, but to me, it's really not a personal services contract at all, because it deals with the lease of a hockey arena for a professional hockey team. It is, at some point, they're granting specific performance by way of the injunction, but the fact is it deals with real estate and the lease, and it is not uncommon at all that for real estate, for truly unique property, that you have specific performance ordered here. That's why this is sort of the hybrid approach, because they do call it under this, where the conclusions of law in 5, 6, and 7, that it's pretty close to a personal services contract, but it really is a lease. And when we're talking about leases or contracts for the sale of real estate, under those circumstances, historically, courts have granted specific performance of agreements concerning real estate, and the reason they have is real estate is unique, and historically that's one of the few areas where you would have seen specific performance ordered is when there are unique goods or it deals with real estate, because real estate historically has been considered unique. Now, I want to move to Johnson versus Calvert and get us into sort of modern day personal services contracts, because we've seen the courts, at least historically, be worried about these cases with how do we make someone an indentured servant, how are we going to police performance of these agreements, how are we going to ensure performance to the level that the parties may like. When we start to think about surrogates and modern methods of having a baby, we've got all sorts of problems with respect to personal services contracts that certainly 100 years ago we wouldn't even have thought of. So first case is this Johnson versus Calvert that opens the door for us here. Mark and Crispina Calvert were married. They desired to have a child. Crispina had previously had a hysterectomy, so the couple decided to go the surrogacy route. And this Anna Johnson heard about her the Calvert's issues and decided to help. She offered to serve as a surrogate for the Calverts. And on January 15th, 1990, Mark, Crispina, and Anna signed a contract providing that an embryo created by the sperm of Mark and the egg of Crispina would be implanted in Anna, and the child would be taken into their home as their child. And Anna agreed that she would relinquish all parental rights to the child in favor of Mark and Crispina. They would pay Anna $10,000, 1993, in a series of installments, the last to be paid 6 weeks after the child's birth, and they would also get her a $200,000 life insurance policy. At some point, the relationship broke down between them, not uncommon. When, well, it depends on who you want to listen to, but they both had disputes with the other. And then it got worse. July 90, Anna sent them Mark and Crispina a letter demanding the balance of the payments due her, and she refused to give up the child. The following month, Mark and Crispina filed a lawsuit seeking a declaratory judgment. They are the parents of the unborn child. Anna files her own action to be declared the mother of the child, and the two cases were eventually consolidated. The parties agreed to a GAL to be appointed for on the behalf of the child who wasn't yet born. So it's just a bloody mess. Okay, if you think you better draft Warner Wolf's contract carefully when we're dealing with warring adversaries, imagine if people are fighting over a child, their child, and in some cases they all see it as their child, and we're going to be fighting, at least in part, about how well you drafted your agreement. That who knows what you would have, well, you're going to have to figure out what you should have put in there. So at any rate, and I need you to think about this because I need you to think about all the parties involved, okay? In surrogacy arrangements, there are the parties that had the initial, what we call procreative parents. The procreative parents are the people who gave birth to the idea of giving birth to a child. Okay, so there's two. Then you need someone to donate the sperm, someone to donate the egg. So now we potentially have 4 people, and both of those latter 2 people could have partners. So now you have 6 people, and then you have the surrogate. So potentially you have 7 people who have, or 8, who have, I believe, some say in what happens here and what happens over the next 9 to 10 months. And so there's obviously pitfalls everywhere. And you've got to think about this because, you know, in 1993, this might have been unique. It's not anymore, right? This is quite common. And usually after I do this class, someone, either in the class or usually by email, tells me, oh, you know, I know we talk about this, but we wouldn't have a child but for this. So, and I think I know multiple people at this point. You may know some as well. So this is something you need to give serious thought to. And unfortunately, a lot of times these disputes, and these disputes are like nothing you've ever handled or will handle again, simply because people are fighting. We're not talking about a house anymore. We're not talking about whether I can keep my job or I can move to my new employer. What we're talking about is that, as I see it, that's my blood there, and I want to raise my child, and they're very difficult cases. So at any rate, now here, in this, by the way, I think this becomes important too, and I think it helps the court. You know, when we talk about sperm donors and egg donors, this is something to talk to your clients about, because to the extent you are biologically related here, as Mark and Crispina were to this child, then the surrogate really become the womb for rent, right? Because you didn't provide any of the genetic material. You, as they would see it, you simply happen to be the place we're going to house this child over the next 9 months. Obviously, it's a lot more complicated than that, but sorry. I ought to turn off that, huh? Okay. So at any rate, the parents, the procreative parents, Mark and Crispina, had provided the genetic material. And that at the end of the day, the court said that they were the biological and natural father and mother, and that the surrogate, Anna, had no parental rights to the child, and that the contract was legal and enforceable against Anna's claims, and terminated any of the visitation that had been taking place. And so then you have their case, and obviously both have arguments for why they are, in fact, the mother of this child, one of which is Anna gives birth to him and housed that child over the period of the next 9 months and felt the child move within her and everything else. And so what the court has to figure out, and they have, is that how do they decide that Anna has no rights under the circumstances. And so at the end of the day, I think it helps here that she was not genetically related to the child, which made it easier. And the fact is that contractually she gave up her rights to raise this child, and therefore she is now bound to it. So I've got a couple questions for you. I'm looking at footnote 10. First I want to ask you about. It says, thus under our analysis, in a true egg donation situation, where a woman gestates and gives birth to a child formed from the egg of another woman with the intent to raise the child as her own, the birth mother is the natural mother under California law. The descent would decide parentage based on the best interest of the child. Best interest of the child is the standard language that we use when we're talking about custody and visitation and all things like that. The problem is that you're going to leave it to something as like this, where so the best interest of the child means that child who is genetically related to me, who is my child in every way but for the fact that my partner couldn't house that child, now becomes a determination of which one of us is financially and psychologically better able to raise the child, becomes somewhat problematic as they see it. So at any rate, what we've got here is this language to think about is procreative conduct. Who are the people that gave birth to the idea of giving birth to the child? In this case, it's pretty easy. It's Mark and Crispina. And so the rest of the decision then follows from there. But I want to ask you some things about this, because I want you to think about some of these other situations that we're looking at now with respect to surrogacy, and I wonder what provisions you would put in those contracts and the like. So first, let me ask you about the note I just read you talked about egg donors. Does anyone feel that you should not be able to sell your eggs or your sperm? So you can sell your eggs?
Well, you can donate, but not sell.
Okay, well, that's what I'm asking. So you would allow them to be donated but not sold?
Yeah.
I think on ethical grounds, yeah.
Okay, so you can't sell them?
Yeah.
Because there's been signs out on that bulletin board out there for people looking to buy eggs.
I say why not sell them?
So why not sell them?
It's your product.
Yep.
I got great genes.
Huh?
I got great genes.
Well, the fact is you can look online as well. The people will give a wish list. Or not a wish list, it's a spec list.
Yeah, I've seen
You've seen, right? You can look it up. They want, certain height, certain weight, certain scores on their boards and everything else, and that's what they're paying for. They're creating this little super race as they see it. You're going to be disappointed as the father of 3 kids. Things don't work out quite the way you think. But seriously, and some of the numbers are like, and by the way, it's a lot more complicated medically to sell your eggs, to produce the eggs. It's a much more involved procedure than donating your sperm. but there have been signs on the boards, and you can look online, like $50,000 to $100,000. And I didn't know it at the time, but we've had students pay their way through law school by selling their eggs.
I thought about it too, I just didn't qualify.
Yeah, you're not gonna qualify, right? But and actually, she works in the reproductive area now, and she sees it as it's a gift that she was able to give other people, and also had to pay for law school. No, it's
Not a bad
and,
way.
and as I told you, others have written me in the past after this class saying, you know, we wouldn't have children but for these possibilities. And you can go online and look at some of these agreements. Boston IVF has their stuff all online, because this is what I need you to think about between now and the next time, okay? Because there's a lot of stuff that has to go in this agreement. So can we're going to write up, I mean, we're not going to write it up, but can the surrogate get paid?
Yes.
You guys going to pay him? Because you wouldn't pay for the eggs, but now I can pay the surrogate?
Just for, because it's more like having a rent or something. You can owe a rent, you know.
Okay, so is there a cap on how much you'd pay?
There is.
How
Should
much?
be. I mean, there should be a reasonable amount that you set for yourself.
Well, why can't we negotiate and buy it? If what I'm willing to buy,
25,000 max
why?
throughout the.
25,000 for 9 months worth of work? That might not even be minimum wage. No, I'm serious, right? 24 hours a day, 9 months. I don't know what the numbers are, but I bet honestly, right? Don't you think?
And the
24 hours a
aftermath
day.
of it, I mean, for a woman to
Right.
carry a baby for 9 months, you're putting your body through 9 months of
Change.
labor.
Torture.
And then she has to bounce back afterwards. And if she doesn't want to
Sex
have.
life on hold.
I want to ask you about that. So I want to ask you about that. Are you going to restrict the surrogate from having sexual relations with her partner? No. Does the agreement say that?
You could. I mean.
Well, I know you could. Are you? Do you think that you can do that? How about what they eat? How about you're going to let them smoke and drink?
Of
No,
course, because,
no, you can't smoke and drink.
Yeah, when,
So-
when you pay the surrogate.
Oh, so when I'm paying a surrogate, I own you.
Now,
No.
Oh no, but you can't smoke or drink and have sex. It sounds like I'm hearing.
Celebrities put stipulations on like what they can eat in their agreements with surrogates.
Well, okay, but why not?
I don't think-
So I don't want you eating certain. I certainly don't want. But the studies now seem to indicate you shouldn't be smoking or drinking, right?
Correct.
I think that's.
So no. So you're going to restrict what they can do in their personal lives.
Yep.
I think it's fair to restrict what they're eating. The smoking and drinking, that's just evident. We don't need to, I mean, obviously put it there, but that's evident. You shouldn't be doing that. Now, as far as sex, I don't know if I'll be restrictive to that, because that kind of creates a little sense of happiness too for that person. So you
Yeah.
know, happy mother, happy baby. You know. So-
Okay, but even before sometimes, so that I need to know that you're not pregnant already, right?
Yeah.
Yeah.
So when you say smoking or drinking, you are putting those in there.
Yeah, for sure.
Okay, and taking vitamins,
Yeah.
Yes.
regular medical care.
Yes.
So you're going to tell me what I can do week to week, day to day, hour to hour over the course of the next 9 months.
Yeah.
Pretty much.
What if I don't do all those things?
That's the $1 million question.
Then
That's a
you
question.
And what, you know what? What if you do, and then we have and I can have you do genetic testing, can't I? So if you're going to do regular doctor visits and genetic testing, and I don't like the looks of this genetic testing,
But
can I compel you to have an abortion?
Now we're talking about stripping the right of choice.
Jeez.
Yes, we are.
Yeah, so I mean, that's
Can
very.
it-
Well, wait a minute. I could do all that, and then you could simply agree to abort. So now I've got all this money and time and heart invested in you, and you could decide 4 months in, you know what? My boyfriend's back in town. We're gonna go to LA. Life is good. I can't do this anymore. No, seriously, and she could abort now?
Well, I think.
My
Well,
child?
We'll get the baby instead if.
No, we're 4 months in, there's no baby yet.
No, but I mean, that's like, the alternative being if neither parties wanted the baby, what would happen with that?
Well, we didn't say that. We didn't do that yet.
Well, I think the pay.
Because that's the question. Okay, so I don't like the genetic testing. I say abort. She says, no, I don't want to. So does that terminate my obligation to support? I mean, it doesn't terminate my biological connection to that child, but there'll be parents that will walk away from that deal,
I say
right?
that's-
I mean, so now I'm gonna, over my objection, I'm supposed to raise a child that might have serious medical issues. These are people that were looking for something, well, that's not fair to say. I was gonna say, some of them are looking for that super genetic race, and this is not gonna meet those qualifications likely.
Yeah, they're very strict.
So tell me what the deal is. Okay, we're running out of time. I want you to think between now and Thursday about, okay, even if you, whatever provisions you put in, and I want to know what others you're thinking about over the course of those 9 months. Life insurance, how about, should we have started with the psychological exam?
Yes,
Psychological exam for everyone or just the surrogate?
surrogate.
Oh, so not the whack job mom and dad?
Oh, I mean, they're paying for it.
Oh, so they're paying for, so we don't need to know about their psychological makeup, because maybe they're gonna get crazy over the next 9 months. Okay, and then the other part of this I want you to talk about, I want you to think about, is this then yet another vehicle that takes care, that hurts the economically disadvantaged?
It does? Yeah, hands down, I have a question about that.
So, wait a minute, so hands down, no question about that? Yes, it does. That's the fastest you've all answered anything. And the answer is, so what? Or
No.
what are we gonna do to protect them then? Because,
I think public policy can say, I mean, for me, it's kind of like a provision against the natural order itself, you know?
Yep.
Because you don't even know what you do with that egg. Like, well, you don't know what is that expected thing.
should it be women who've already had a child?
Not necessarily.
Well, I hear that, but here's the logic behind some of that, is that if you've had a child, then you would know what it's like to give up that child. And you may only understand that after you've given birth, right? And plus it also says that medically you should be able to bring the child to term, because that's the other part of it. Now you've seen, it should be a family member. You guys, we've sort of blown past, can you pay the surrogate? Maybe if we did it that you cannot pay them, then it would be out of love and a family member, and that would seem to solve some of the problems. There was a case that a mother gave birth to the child, the grandmother gave birth for her daughter to the child. Grandmother gave birth to the child because her daughter couldn't bear the child to term. Okay, I need you to think about what you're going to put in the contract. I need you to think about what happens when it goes bad. If you want to look at Boston IVF, it's an interesting, the contract obviously is yay thick, but there's a lot of problems with it that we've got to talk about. Some of it's going to be cured by various state statutes and the like, because the states decided that they better create a system here to try and help in some way. But we'll talk about it on Thursday.
Never even thought about all those pitfalls that come along with that.
Oh, it's bad.